So, how do motorcycle accident injury lawsuits work? Well, there's generally two things you need to prove. And if you have a very small claim, an injured person might be able to bring a claim for their injuries after a motorcycle crash without hiring a lawyer. If you've got more significant injuries, though, it probably makes sense to get help from a lawyer. Um, so, what would that entail? Well, if an injured person hires a lawyer to bring their claim for motorcycle injuries, there's definitely some pros and some cons. The pros are that the lawyer is going to work on a contingency basis, which usually means that your lawyer is going to front the fees and costs. They're going to work on the case and not bill you for it. And then at the end of the case, after winning, then the lawyer is going to take a certain percentage of the winnings, and then the rest goes to pay for the fees and costs of the lawsuit and goes to you. So unlike in regular business law where a lawyer says, hey, I charge $300, $400, $500 an hour, and then you got to write them a check every time you get a bill, this way the lawyer is going to represent you. You're not out of pocket. And then at the end, the lawyer is going to take a fee. So on the plus side, you can get a skilled lawyer to bring your claim for you, and you're not going to have to write a check every month for a whole bunch of money. And the lawyer is going to do all the work. They're going to front the fees. They're going to do the legwork for you. So your participation is going to be pretty small. Of course, the downside of hiring a lawyer is that they do cost money at the end. So typically a lawyer is going to charge a third, maybe 40%. If it goes through trial, it might even be more than that. So you've got a rather high cost compared to doing it yourself. But if you have a significant injury, it probably makes a whole lot of sense to hire a lawyer, not just to be able to navigate the legal system, but oftentimes what will happen is most of these cases settle and don't go to trial. So frequently what happens is when you hire a lawyer, the lawyer, I don't want to use the word knows the tricks of the trade because it's not really tricks, it's the law, the experience. A lawyer is often going to get a significantly higher settlement than somebody would who is not represented by a lawyer. Now, if you are representing yourself, you may get a lower number. And if it's a small claim and a lawyer is going to take a third of it or 40% of it, maybe it doesn't make economic sense and maybe it's better for you to do it yourself. It's a small claim. So what actually has to be done in order to bring your motorcycle injury claim? And this will kind of help you decide whether or not you may need a lawyer. So anyway, there's two things that you need to prove. The first thing is liability, that somebody else is at fault for causing your accident that injured you. And the second thing you need to prove is your damages, which is the legal term of saying, hey, you were harmed by the accident and the harm equals this much money. And the way to do these things is, well, I'll try to break that down a little bit here. So to show that the other person was liable or at fault, you're going to use evidence like what? Well, you're going to have a police report, hopefully, and the police may be ticketing the other person, and that really is good evidence to show they're at fault. You might have statements from witnesses. You can, grab your cell phone, record their statements, and that'll be really helpful. Of course, get their contact information, so if you need to track them down later, you can. Lots of people nowadays have videos in their cars. Maybe you've got one on your helmet. Videos are great. That expression, a picture says 1,000 words or something like that. Kind of true. Videos are even better. Of course, yes, they can be manipulated these days. You always have to be careful of that. But if it's your own video or some non-biased person, you can rest assured that they're probably not being manipulated. So you've got pictures, you've got videos, you've got witnesses, you've got testimony. All of this information is used to prove liability, prove that the other person's at fault. So once you get over hurdle number one, then it's time to get to hurdle number two. And hurdle number two is proving your damages. And that just means essentially the amount of money that you were damaged as a result of your injuries. And so that's going to include your medical bills, your past bills. If you still need treatment into the future, it's going to be your future bills. If you missed work, it's going to be your lost wages from work. If you've got other expenses you've incurred because of this, then that'll be included too. So the way to do that is actually go and get your medical bills, get your medical, let me break this down a little bit more. You need more than just your medical bills saying, hey, I went to the hospital and it cost this much money. You actually need your medical reports. And the reason for that is because The medical reports will show that you went to the hospital because of your injuries resulting from your motorcycle accident, not because of your pregnancy or your strep throat or emphysema or whatever you went to the doctor for. So even though it's personal, the insurance company for the person that caused the accident is going to need to see your medical records so they know that the treatment you received resulted from the accident. And then they need to see the bills to see how much the bill was, so they have numbers they can put to the treatment. Then the other thing that's important too is if you missed work, you're going to need something from your employer that shows how much work you missed. If you missed a day, okay, that may not be a big deal. But if you missed weeks, a month, something like that, you're going to need something that'll show them, hey, look, I made whatever, $1,000 a week. I missed 3.5 weeks. And then, simple math shows simple math. You just show them a total of how much you missed of work. And then the other thing you want to demonstrate, which is a lot more cloudy, is pain and suffering. And what that is, it's an amount of money you get for exactly that, your pain and your suffering. If you had a really crappy night, but you felt good the next day, your pain and suffering is going to be really small because it was a very short period of time. And certainly you can tell them how long you had pain and suffering for, but medical bills are even better. So if you went to a doctor and you're treating for weeks or months or years, then you want those medical bills to be provided to to the insurance company for the at-fault driver, so they can say, wow, this guy really treated for a long time for his injuries or her injuries, because that shows that the pain and suffering number is not tiny, but it's actually going to be pretty large. So the reason you need to get all this information to the insurance adjuster for that party that's at fault is because they're going to take all of this, they're going to do what they call an evaluation. There's lots of computers. They have their own proprietary systems, and some they'll do things like roundtable meetings with management and say, look at all the data. So first they have to prove that the person they insure caused the accident. That's number one, liability. And once they get to that hurdle, then number two is the damages part, where they're going to decide, okay, what's this thing going to cost us to get rid of? And they're going to come up with a range. And this will be sort of their settlement value. And if you give them all of that information, then they're going to make you an offer to try to settle the case. And the offer is going to be at the bottom of the range, not the top of the range. So don't feel insulted. This is just how the process works. Now, let's say that they've made their analysis, you've given them all the data, and they come back with you and they make you an offer. You don't like that offer, so you make a counter offer to it. And so you're trying to get a higher number, and then they're going to come back to you and say, hey, look, okay, we're going to raise our offer up here. And eventually the two of you sort of meet and you reach what's considered to be a settlement. So what happens then? Well, they're going to send you something called a settlement agreement or a settlement agreement and release. And it's literally a contract, and it says lots of things, but the important part of it is going to be, it's going to have your name. It's going to talk about the accident. It's going to, identify it. And it's going to say they're going to pay you X dollars. In exchange, you're going to release all claims, known and unknown. And so what this means is you sign it, you give it to them, they give you a check. You're done completely. So the important part here is they may offer you, I don't know, $5,000 a week after the accident and say, hey, take this $5,000, sign a release, we're all done. And you might be thinking, okay, great. Here's my signature. I'll take the $5,000. We're done. And then 2 days later, you go to the doctor and say, hey, you know what? We just finally got to look at your MRI, and it looks like you've actually got a fractured vertebrae, and now you're going to need spine surgery. Well, you want to go back to the insurance company and say, hey, I didn't know this before, but I need spine surgery now. It's going to be, I don't know, $100,000. So we need to reopen this claim and renegotiate it. And the insurance company says, no. You signed an agreement releasing all claims known and unknown, meaning that even though you didn't know about the need for spine surgery when you signed this, it doesn't matter. We're still released of all claims. So be very careful about taking a early small settlement. Make sure you've had your injuries looked at. Go see a doctor, go get checked out, because you don't want to be in a scenario where you need a ton of medical care as a result of the accident, but you already signed away your life and you can't bring a claim anymore. So let's say that you and the insurance carrier negotiated and you did not reach a settlement. So then what happens? Well, you're going to file a lawsuit. And when do you file a lawsuit? Well, different jurisdictions have different, they call a statute of limitations, meaning a period of time where you can file a lawsuit. I'm in Nevada. Here in Nevada, the statute of limitations for a personal injury lawsuit is 2 years. So that means you have to bring your claim within 2 years. And if you wait 2 years and one day, your claim's extinguished. It's gone. You cannot bring it anymore. So be sure to be very aware of the statute of limitations, because insurance companies may talk to you and say, how's it going? Okay, well, let us know if anything changes. And they may hope that you blow through the statute of limitations so your claim is gone, and then they're going to pay you nothing. So be aware of your statute of limitations. And then what happens when you bring a lawsuit is you initiate it by drafting something. It's called a complaint. And it's a legal document, and it talks about the accident and the injury, and your claim for damages are going to look slightly different in different jurisdictions, but that's what starts the litigation. So that document, the complaint, has to be filed within the statute of limitations, gets filed with the court, and then it has to be physically served on the party who you're suing, and then they will file a response to that, which is often called an answer. And then that begins the litigation process. And so what happens next, oftentimes you'll have, the fancy word is discovery begins. And that's lawyer speak for saying, let's go find all the facts. And so this may begin with something called written discovery, which is where the lawyers, or if you're representing yourself, you'll send written questions to the other side. Hey, where were you going at the time of the accident? What were you doing? Do you own the vehicle? Were you at work? What color was the light? All of these things. And that will go to the other side. Generally, the lawyer on the other side is going to be preparing all the responses and just checking with the client for help. So it's going to be pretty well sanitized. You're not going to get a ton of information from it, but it's helpful. So everyone does it anyway. There's also going to be depositions, and a deposition is simply you and the other side and the other side's lawyer. And if you have a lawyer, your lawyer's there too, and a court reporter that takes down everything you say. If you're taking the deposition of the party that was the driver that injured you, then you're going to be asking them questions, and it's going to be very similar. What's your name? Where are you from? Where are you born? Who lives with you? Where were you going? What were you driving? Did you have any alcohol? Did you have any drugs in you? Were you texting? Were you on the phone? You're going to try to get evidence to support your case, and they're going to depose you and ask you questions to try to support their defenses. If there are experts involved or witnesses involved, those people are going to get deposed as well. So that's one way to get, this oral testimony that's going to be helpful for each side. Each side is going to try to get facts out to help them. So if you're bringing the lawsuit, you're going to try to get facts out that help you prove the other side was at fault and that help you prove the amount of your damages. The other side is going to be taking your deposition to try to show that you weren't really injured that much, or maybe that you were really at fault, and that maybe your medical care is not all related to the accident, and that maybe you've been able to do lots of things in real life that you say you can't do. So it's very important to be on the ball for these things. So documents are also exchanged, things like insurance policy, photos, videos. So each side has the evidence that the other side has. So for you, it's helpful to know important things like how much insurance does the other side have, because if they only have $25,000 of insurance, let's say, and you're trying to get $1 million, well, you probably don't want to spend $100,000 on litigation if at the end of the day you're only going to get $25,000. Similarly, the other side's going to try to find evidence about you and how bad off you really are, how severely injured you really are, so the insurance company can make a reasoned decision and try to resolve this case. During litigation, oftentimes there'll be a mediation, and that's just a very simple process where you have a mediator who's sort of a neutral that tries to bring both sides together to settle the case. Literally, you may be online or you might be in an office, and the mediator will come in and talk to you and your lawyer, if you have one, and say, hey, what's the case all about? Tell me about you, tell me about your injuries, tell me about what happened. And then they'll leave and they'll go to another office where the defendant is and their insurance company, and they'll say, hey, look, the person bringing the claims, really great person, real injuries, still not healed. You're going to have to pay a lot of money on this one. And of course, then they'll come back to you and say, well, you know what, here's some holes you have in your case. And so the mediator is going to try to bring both sides together to reach a settlement so the case resolves. Now, if the case does not resolve, there's more things that are done. They call it motion practice, but basically this is legal stuff where both sides are going to try to knock out each other's evidence. And so if you're going this far, it's probably really going to be helpful to have a lawyer if you're not in the legal industry, because it's somewhat easy to get tripped up here if you're not really skilled in this and do it every day. But at the end of the day, if the case doesn't settle and you're actually going to trial, which happens in a very, very small percentage of cases in the personal injury world, that's going to be a lot of work. It's probably pretty darn tough to go to trial if you're not a lawyer or if you haven't spent a ton of time in the legal industry. Of course, you are allowed to represent yourself and you can go through all of this yourself if you want to, but you're going to have a lot of preparation involved. You're going to have to work on jury questionnaires, which are, if you do those, they're going to be questions for a jury to help select out a jury. Lots of courts don't do that, so you're going to prepare your questions. It's voir dire is the picking of the jury. Once the sides pick the jury, each side has opening statements. They're going to tell the jury what they expect to demonstrate during trial. Then the plaintiff, the person bringing the lawsuit, gets to go first, and they put on all their evidence. You want to show, witnesses, police reports. Well, you're not going to be showing reports in trial. You're going to have the policeman or policewoman there saying, this is what I saw, these were my observations. And you want to use that testimony to show that the other person is at fault. Other witnesses, you'll present them as well. The other side's going to have an opportunity to cross-examine them. And then once you're done with your case in chief, then the defendant's going to put on their witnesses, their experts. You're going to have a chance to cross-examine them. And then at the end of it all, there's going to be closing arguments or closing statements where you'll be saying, hey, look, you saw all this evidence in trial, and based on all of this evidence and the law that the judge is going to give you, you should find in favor of me, and I should get this much money. And the other side's going to get up and say the opposite. And then at the end of the day, you're going to have a verdict from a jury. And after the verdict happens, there may be some motion practice for fees, costs, things like that. And if somebody's really, really upset, then they may want to appeal it to the appellate court, and this will continue potentially for years. So all of this is very time consuming. All of this is very expensive. So this is why insurance companies like to try to resolve these cases early. So anyway, hopefully this was helpful. This is certainly not a complete overview of how trial happens and how all of litigation works, but at least it's a little bit of a glimpse into the process so you can make a better decision on how you want to proceed with your motorcycle claim if you've got one. Thanks for watching.